I'm just gearing up. The first thing we're gonna look at, we got a lot of stuff we're gonna look at. The first thing we're gonna look at, we're gonna watch a video by Judge Scalia. It's called The Role, and I want you to understand this. I'm gonna preference what I'm gonna say by saying this. You got to understand the principles of the principles apply on the state and federal level. We got what's called separation of powers. Okay, so Article 1 cannot exercise the same powers as Article 3. So if you got an Article 1 court, there's no way in hell it can exercise the same powers as an Article 3 court. They're two different kinds of court, and separation of powers prevents them. Now, Article 3 judges are usually in an appellate oversight of Article 1, but there's a lot of stuff that goes over in Article 1 that has no judicial oversight, like the indictment process. That's why anybody gets indicted. There's an attorney, she did a video on YouTube saying that you can indict a ham sandwich. I'm gonna pull that up right. Because we got to use their stuff. Because if we don't, they'll be coming at you talking about, where that attorney say that you can indict a ham sandwich. I probably had to go in my files and pull that up. But she just came in and she basically told everybody what it was. You know, when you get an indictment ain't nothing. They can indict anything. Just because, oh, you got indicted. You know, they indicted President Trump. That didn't mean anything to me. Everybody gets an indictment. I ain't never seen, they always say they came back with a true bill. Always. I mean, it's like 100% of the time. And an indictment is supposed to be when you do a presentment to a grand jury, but now you can't even be present, or counsel for the opposing party can't even be present when they're in there in the grand jury. When they presenting evidence to the grand jury. And some of these grand jury indictments, I think they rubber stamp. That's just for me doing indictment or release request in jail, and I have like 70 of them I do at the same time. They all come back the next day indicted. And you telling me that y'all took all 70 of these in front of a grand jury? Come on, man. Come on, man. I done seen too much. Y'all might can get that over on another person, but you ain't gonna get it over on me. And I'm gonna tell all my people what is going on. So the first thing we're gonna look at, we're gonna look at the role of the Supreme Court under the Constitution. Now, we gotta really watch this right here. And there's going to be a part 2 because I'm going to pull out the Supreme Court analysis and interpretation of the Constitution, because there's going to be some things said in here that I'm going to ride off of. So let's see if I can get it queued up. And here we go.
Certainly.
Thank you, Justice Scalia and Justice Breyer, for joining us. It's an honor to have you here today. Justice Scalia, I wanted to follow up on some things you had said in your opening statement, along the lines that it is and properly should.
Okay, first of all, I want to give some backstory. First of all, this is a judicial committee, a judiciary committee. This means that the legislative branch of government has formed a committee, and now they're calling in the Supreme Court justices from Article 3 to have a discussion. And discussion is centered around what laws they will strike down, okay? Because Congress all the time will pass unconstitutional laws. So we're here to have a discussion on what is constitutional versus what is not constitutional. So you got Justice Breyer, Justice Scalia, you got all these guys in here before them to answer some questions. And Scalia, he is what is called an originalist. All right, so you got originalist judges, and then you got these judges that say that the Constitution is a living document, which means it changes with the time. Usually those are the liberal judges, and we got a couple of Jewish ones on the Supreme Court. And I don't think I'm wrong for calling that out, because most of the time, if you're a Democrat, you're a liberal. It's just liberal is just another name for communism. That's what you're not telling the American people. And I'll challenge anybody on that. Liberal is just another name for communism. It's communist. It's socialism is what it is. Socialism, just another name for that. Today, all right? So we want to make sure, I'm giving you the backstory now. So you got the senators and you got Supreme Court justices. They having a committee and to discuss. So you have Article 1 and Article 3 in the same room. And because, see, what happens is when you look at United States Code annotated and United States Code, if you look in the beginning introductory of those books, you see that the Supreme Court has approved those. The reason you have procedures is because they want to make sure there are no constitutional violations. So everything in the public goes by a procedure. It's like when an officer shoots somebody down. Well, his superiors, they're going to review everything, and as long as he follows procedure, he's immune. That's what gives them their immunity. As long as they stay within the ambit of their delegated authority, they're immune from any liability. Well, they ensure they stay in the ambit of their delegated authority. Everybody in the public is given procedures. That is letting you know that you're dealing with something legislative in nature. You're not dealing with anything, Article 3 in the Constitution, because they have to have procedures in place to ensure they don't violate the Constitution. But they do it all the time. They draft laws and everything that are unconstitutional all the time, and the reason they get away with it is because we don't challenge it. So today, we're going to look at this. Thank you for the 20 bones, Pauline Filippi. All right, so let's look at Judge Scalia mysteriously ended up dead in Texas. Mysteriously ended up dead in Texas. This is one of our best Supreme Court justices we had. Let's look at it.
Certainly.
Thank you, Justice Scalia and Justice Breyer, for joining us. It's an honor to have you here today. Justice Scalia, I wanted to follow up on some things you had said in your opening statement. Along the lines that it is and properly should be a difficult, cumbersome, time-consuming process in our constitutional republic to enact legislation. I think the courts can and should play a significant role in ensuring that that's always the case. The court certainly has played a role in the past in cases like INS v. Chatham, in which the court has stepped in and said, you know, notwithstanding the fact that you, Congress, may have found something that makes the process of legislating easier or perhaps even more efficient or collegial, you haven't dotted your I's and crossed your T's in the same way that we contemplated under Article 1, Section 7, Clause 2, requiring bicameral passage and then presentment. And so this provision.
Certainly.
Thank you, Justice Scalia and Justice Breyer, for joining us. It's an honor to have you here today. Justice Scalia, I wanted to follow up on some things you had said in your opening statement, along the lines that it is and properly should be a difficult, cumbersome, time-consuming process in our constitutional republic to enact legislation. I think the courts can and should play a significant role in ensuring that that's always the case. The court certainly has played a role in the past in cases like INS v. Chatham, in which the court has stepped in and said, notwithstanding the fact that you, Congress, may have found something that makes the process of legislating easier or perhaps even more efficient or collegial, you haven't dotted your I's and crossed your T's in the same way that we contemplated under Article 1, Section 7, Clause 2, requiring bicameral passage and then presentment. And so this provision is invalid. So let me ask you the question, is there also a role for the courts? Can you foresee a role for the courts in other situations in which Congress, some future hypothetical Congress, might do something different that would prove easier and more efficient and more collegial, but perhaps in a way that's antithetical to the Constitution? For instance, let's suppose that Congress, when legislating on the delicate and pressing issue of maintaining the proper records in the dog breeding industry. Since we're talking about federal legislation, these would of course be dogs either moving in commerce or taking advantage of some channel or instrumentality of interstate commerce.
And there it is. There it is. Okay, I want y'all, that point that senator just said, he said, since we're talking about federal legislation, we're talking about something with interstate commerce or in some sort of instrumentality or moving in some sort of channel of interstate commerce. That is all they have jurisdiction over. Anything commercial. I don't know why these people try to, it's so much evidence in everything that I've read to test to this. I can't believe that anyone would even have the nuts to even come up and try to say it's not true. I just don't believe. I've read indictments and everything. It's in there, interstate commerce. It's commercial in nature. This gets into the right to travel and all of that. Is it a commercial activity? So what he's about to tell them is this. He said, look, it's separation of powers. If we're dealing with something commercial, we don't even have to come and talk to you because there's something called plenary power doctrine, okay, where each of the individual branches of government, when they're exercising the powers that have been delegated to them under the Constitution, the other branches of government cannot say anything to that branch. So Article 1, Section 8, Clause 3 is the Commerce Clause. So they have been delegated that power. So now they're questioning, and this judge, Scalia, is the one he wants to concentrate on, not Breyer. They don't like Scalia, is what I want you to peep out. They don't like Scalia. So they really hear it, but now they're respectful because this is a real fucking Supreme Court justice. I'm going to show you how they treat a judge that's not I'm going to show you how they treat an administrator that's under their authority versus a Supreme Court justice. So this is a Supreme Court justice, all right, and he's asking him a question. Okay, well, let's say it's moving in interstate commerce. Like it's a fucking trick question or something like that. Because they were saying, well, bicameral passage means the House and the Senate got together and they approved it, and you have to make presentment to the president of a bill, and he signs the bill into law. That's how laws get made. Or if he vetoes the bill, he can come back and 2/3 vote, they can still make it a law. I hope everybody watched Schoolhouse Rock when they were growing up. All right? Because I learned that shit when I was like 5 or 6 years old. Okay, so let's see. If you can listen to this right here and follow along what's going on, you're gonna be all right. That's why I'm doing this, okay? So let's look at this real quick. Let's keep going.
But a law in which Congress just passes a law saying we're outsourcing, we're delegating the authority to regulate dog breeding and record keeping for purebred dogs to the Board of Directors of the American Kennel Club. That passes both houses of Congress. It goes to the President. It's signed into law, and we then have outsourced the regulation of this practice to the American Kennel Club. Is that a situation in which you can anticipate the court might step in?
Well, I would step in. I don't know if the court would. I was the dissenting vote in the first case involving. I hate to mention this with my friend Stephen here, since he was on the Sentencing Commission. I thought when Congress created a sentencing commission to decide how many years everybody should spend in jail, because presumably Congress didn't have the time to figure it out for themselves and just left it to this commission to do it, I didn't think that that was constitutional. So I
Did you hear what he just said? That y'all do know what sentencing guidelines are. That's how everybody in federal prison gets time. Okay, with sentencing guidelines. Okay, that was commission. Now, sentencing guidelines is something that is promulgated by the legislature. All right, when you go into a U.S. district court, that is an Article I court. Everything Article I starts off with U.S. citizen. Congress created that. U.S. district court, legislative court, U.S. Postal Service. All right, anything U.S. is owned by the legislature. It's legislative in nature. Congress exercises plenary power and authority over it. They just allow the Supreme Court to exercise appellate jurisdiction over their proceedings to make it look like they're doing, because they have to, because they can't violate the Constitution. Because ultimately, the protectors of the Constitution are the Article III judges. But they also took an oath to uphold it. And he's going to make that clear to him. You took an oath to uphold the Constitution as well. So right here, Scalia just put him on blast. He took this opportunity. He couldn't wait because he understands what's going on. He took this opportunity to throw right in their face, that shit y'all did was unconstitutional. Putting that on us, Article 3, to decide how many people go to prison and how much time they get, when you know these are Article I courts, that's a legislative jurisdiction, and we shouldn't have nothing to do with that. What did he mean when he said it was unconstitutional? Why don't y'all people on those sovereign citizen videos, why don't you go do a video on this and explain this to all your listeners? Since you're so concerned about the people and educating the people and how people are defrauding people, why don't you take your ass over there and do something meaningful instead of that sideshow that you got going on? Why do you care if people are trying to be sovereign citizens? My understanding was it was only like 1 million of them. I think it's a lot more than that, because I know it's new people every day going through the judicial system and seeing what a piece of shit our judicial system is. And they can't get no help from no attorneys. Every single person I talk to has a problem with their attorney. And this is why I told people, y'all need to put together a website. Since these attorneys want to talk all this shit, put together a website devoted just so people can do reviews of attorneys all over the nation. You will make a lot of money on a membership, and that way we can get a consensus on what type of job these attorneys are doing in the United States of America, if you really want to find out. Because what that will reveal, like, damn, why everybody coming in here with the same story? Because I already see it. My attorney didn't do shit for me. I paid this motherfucker $20,000. As soon as I ran out of money, next thing you know, he offered me a plea deal and I'm in jail. I paid him $50,000. I paid him $200,000. Paying the amount of money you pay an attorney don't mean nothing. It don't mean anything. That's not going to be an ultimate arbiter of how well of a defense that you get. They make you think that, but it's not. And you can read, if you don't believe me, go to the Protocols of the Learned of the Design and protocol number 17 and read that, and then look at how the judicial system is being ran and see whether or not what they said they were going to do, whether or not they're doing it right now. We'll talk about that a little bit too. We'll talk about that a little bit too in a little bit. Let's get back. So right here, I want to get back on this. So Scalia just threw in his face that they're forming a commission. This is a commission. They commissioned them to do this. It's called delegation of powers doctrine. This is how you can have an Article 3 judge sitting in an Article 1 court. They can delegate their powers. The legislature can delegate powers to Article 2 and Article 3. However, they can't delegate lawmaking powers to those branches, but they do delegate powers to them to fulfill the wishes of the legislature. See, all the executive agencies are under Article 2. So you see Homeland Security at what? The airport. It's called a commercial airline. That's under the authority of Congress. Y'all better wake up and start paying attention. Y'all better wake up and start paying attention. This shit is not easy. These people think you stupid. This is, once you understand what I'm talking about, it's easy to see. They not hiding anything. The problem is half of the United States of America reads on a 7th grade level. That's the issue. And the other half of y'all don't want to read. When we supposed to be exercising oversight over these people. We don't know kings in the United States of America. These people work for us. And they don't have to do that because they see these dumb motherfuckers don't know. I heard a judge say one time, it's a shame that public servants have to tell private citizens what to do. And I agree. It's a shame y'all have to go into a public venue and get a divorce and then have a public servant tell you who gonna see their child and for how long. I agree. It's a lot of immature shit people do. But the only reason that's happening because you got away from God. Because the only grounds for a divorce is if you have adultery. That's why ain't none of these marriages working. And really, to tell you the truth, the only woman that qualifies for marriage is a virgin. Marriage was for virgins. It was not for women who have sex with multitude of men and decide they're tired and paying their own bills, and you decide you want to get married. And then you men are wifing up these women. And then wondering why you're having problems, wondering why 80% of them are filing for divorce against you. Man, there's about, I think it's something like 1,400 bridal shops have shut down in the United States of America. I forgot, I got to go look at the number again. All the bridal shops, because it's only like 30% of the people married right now. Marriage is like, they're destroying the country because the family is the cornerstone of our country. And that you can see that they are systematically destroying families. And you think that's an accident? You think that this court system is biased against men? That's an accident? Somebody got to say it. Because a lot of you men, y'all scared to say it. I don't even understand how a man's scared to tell a feminist, anybody, anything. I don't even understand where that fear come from. Go find your nuts and report back. Because a lot of you men nuts have fallen out of your nutsack and is rolling on the ground somewhere. And somebody else picked that shit up. And 9 times out of 10, it was a woman. Yeah, see, somebody said it. Same here. Paid him $7,500 to take it to trial, and dude with a $3,500 retainer, only to wait till the last minute to plea out to a 20-year sentence. That happens happen to everybody. It's 95% of the people. Hold on, we're gonna go back to this. Let's finish this. Get back to this real quick.
I am sure I wouldn't like your dog breeding body either, but I can't speak for the court. I don't know what the court would allow.
But for you personally, looking at it, notwithstanding the fact that it's more efficient, notwithstanding the fact that you do have bicameral passage and you have presentment of this hypothetical law, the problem is that you have delegated the lawmaking power.
Exactly.
Exactly. You have to be careful because John Jay, I just read this in John Stevens' book, it's pretty good. The first chapter, he says, John Jay, first Chief Justice. And George Washington went to him and said, I have a lot of questions here. I don't want to do anything unconstitutional. Here are a bunch of them. Will you answer them? And John Jay said, no advisory opinions. He said, we're not giving any advice. But the real reason, of course, is he didn't know the answer.
and this is where I disagree with Justice Breyer. I read that with John Jay. Okay, that's what I was talking about when I'm going to go in and get under the analysis and interpretation of the Constitution by the Supreme Court when I was in there studying Article 1 and Article 3 courts. What John Jay was asking them, he's like, how can a judge have two hats? Isn't that how can I be serving under Article 1 and Article 3 at the same time? This is when that delegation of powers doctrine, this is why he's like, he's trying to cut it off. He all grinning and shit. You know, look at him. He grinning out, you trying to cut it off. And no. You need to go read that and study that for yourself. Because I did. And they don't like John Jay. You're going to see that. Because these were the original Supreme Court justices under Chisholm versus Georgia, which they don't teach in law school. They don't teach the court cases, one after the other. They pick and choose what cases they're going to teach these law students. But the first Supreme Court case was Chisholm versus Georgia, where the determination was made that the people are sovereign. Now, I got a guy on here, Chisholm versus Georgia, Randy E. Barnett. He's an attorney. For all you attorneys out there don't like what I'm saying, I'm going to cite one of your own. He has a white paper discussing this. Matter of fact, I might do a show on that because it's real good. It's a real good white paper. We'll talk about it a little bit. But we got to get to the bottom of this. What kind of court are you going into? That is the crux of the major problem that y'all are having. Why y'all don't understand what is going on, because you don't know. You just hear the word court. And you just, I'm just going to court. I'm just going to court. You don't know what kind of court it is. Is it a basketball court? Is it a tennis court? What kind of court is it? Is it an Article 1 court or Article 3 court? Is it a legislative court? Or let's not even use Article 1 and Article 3. All right, because this guy got a phrase in that. Is it a legislative court or is it a judicial court? Because all the branches of government have their own court system. Congress has its own court. That's under Article 1, Section 8, Clause 9. And then the judiciary has a court, and the military has a court. So what's never written, now the commercial courts, when we go and study the history of commercial courts, all right, that last about 4 years, they merged the commercial courts with the U.S. district courts. Go and Google commercial courts merging with U.S. district courts and read it for yourself. And watch some light bulbs start. So they merged the commercial courts with the U.S. district courts. Now, who has the authority over commerce? The legislature, Article 1, Section 8, Clause 3. So he had the authority to merge those courts. Congress. It couldn't be the judiciary because we got one Supreme Court. This is the question they don't never want to answer. This is why I come into the courtroom and I say, is this civil or criminal? It's criminal, thank you. The Constitution for the United States of America only grants this court 2 criminal jurisdictions. One is under the common law, which would be an Article 3 court, and the other constitutes a condition of contract under criminal aspects of a colorable admiralty jurisdiction, which would be an Article 1 court. Because to be brought in an Article 1 court, you got to be under some sort of contract. It's an implied contract. George Mercier wrote a white paper, the best white paper that you can read. It's called Invisible Contracts. The man is high IQ. High IQ. It's called Invisible Contracts. That is what is connecting you. Since we've been doing this, that's what you're asking. That's why everybody says, I don't agree. That's what UCC 1-308 is about. I'm not agreeing to be in a contract that I'm not agreeing to voluntarily with full knowledge of all the material facts. You just putting me in a contract and ain't telling me everything that's involved with that contract. It's an implied contract. When I agreed to be a U.S. citizen, when I put my children in public school, when I register my car, when I use Federal Reserve notes, when I open up a bank account, when I use my social security number for anything, there's a presumption I'm a U.S. citizen. We're gonna look at that U.S. citizen too. We're gonna look at that too. Let's finish listening to then, but I want to give you some backstory on that John Jay. Okay, that's what he's talking about. The question that was posed to George Washington, okay, when they were establishing at the aborting of all of this, he was asking him, he said, hey man, how a judge gonna wear two hats? That seems unconstitutional. How they made it happen is through the delegation of powers doctrine. If you're gonna understand any of this, you gotta understand delegation of powers doctrine. Write that down. Because they don't expect y'all to know all this stuff I'm telling you. There's no way in hell any of y'all would figure out any of this. No way. No way. Ain't no way. There's no way. There's no way the average American citizen would figure out any of this. It just wouldn't happen. I can't see it. The amount of study, the amount of reading, the aptitude that is required to understand this, I don't see it.
And he was right, and he was right. And his tenure on the court proved to be short-lived in any event.
Now, the situation you pose is quite different.
You see how that senator threw a jab at him? His tenure on the court tended to be short-lived. They don't like John Jay. You got to catch these little things. See, when you know the backstory, you can understand what's being discussed. You know, okay, this dude don't like John Jay, because they were talking about the American people are sovereigns. And they believe that the sovereignty is vested in the government. And they believe like the 9th Amendment changed the decision of Chisholm versus Georgia. No, it didn't. Not the 9th or the 11th Amendment. That's what Randy E. Barnett, that professor at Georgetown University, he wrote the white paper he was discussing, which I understood that also myself. How you going to, like they said in the case, he said, how y'all going to have sovereignty? If y'all to have sovereignty, the American people had to be sovereign. You can't get sovereignty. You have sovereignty. The sovereignty of the United States is qualified. It only within the ambit of their delegated authority, that plenary power that you exercise under territorial jurisdiction is where you exercise your sovereignty. Stop trying to make people think that you got this all-encompassing authority over everything. You don't have no authority over private property or private individuals, which is why y'all love communism, because communism is the elimination of private property. I read that out of Karl Marx, the Communist Manifesto. I believe it's on page 2 or 3. We can read that too. But they don't like John Jay. They don't like any of the original. There was only one person that dissented in that decision. Should let you know something. But Judge Iredale, he's the dissenting. He had the sole dissenting opinion in that case. But it was, that's why I don't understand. What do you mean sovereign citizen? I've never seen the word sovereign citizen in reading case law, but I see the word the American people are sovereign all over the place. So y'all done coined this phrase sovereign citizen is like really calling a person a nigger. That you can't find in no court cases. If you ask them, where did you get that word sovereign citizen? And please tell me where you derived that definition from. If you're making reference to that, because I take exception to you labeling me something that I can't find in a dictionary nowhere.
Different, of course, from your leaving it to an agency to
So how is it different then? How do those differ?
Well, because when you leave it to an agency, you are giving it to the executive. The executive can make rules. You can't run an executive operation without making rules. The doors open at 8 o'clock. If you're the Interior Department, you can't have fires on public land. You can graze private cattle on. It's up to the agency to make rules. But there is an obstacle that discourages you from giving too much power to the executive agency because you are increasing the power of the president. You're a competitor to the president. You know, the separation of powers with different branches competing. And there is no such disincentive when you leave it to this private group that you're talking about. That is just a pure delegation of legislative power. You are not authorizing an executive to act like an executive, but you are delegating legislative power to a group that has no executive responsibilities.
So the difference you would insist is based on the fact that this is an executive branch agency, which at least in theory is subject to the disposition, subject to the control, to the direction of the chief executive.
I think that's right, and I am what can I?
Judge Scalia, I'm inclined to agree with you, and I would laugh too. Of course, an executive agency is subject to the authority of the President of the United States. That's what they are. They're executive agencies. Okay? An executive agency, when you delegate authority, they can regulate activity and they can make rules for their internal operation. Okay? So a lot of you guys like to say, well, they issued an executive order, which is the most idiotic shit that I've ever. Well, they issued an executive order is for the employees of the executive branch, fool. Don't have nothing to do with you. The president is the chief of the armed forces. He gives orders. Executive order. So these rules and regulations is for their internal governance, for the things that they have the authority to regulate. Here he's talking about delegation of powers, where the legislature has delegated power to an executive agency of government. He's going to get into a little bit. So he asked him, well, it wasn't good because what, because they're subject to the president. Like, yeah, you got separation of powers. There's 7 principles of the Constitution. Separation of powers prevents them from, we put that so no one agency of government, no one branch of government will be an authority. This is why I don't understand. Everybody talk about the president. The president is just the chief of the executive branch of government. The most powerful branch of government is Congress. They're the ones y'all need to be looking at. They can declare war, do all kind of things. But something changed in 1933. Something changed when we started getting Social Security numbers and the New Deal program under Franklin Delano Roosevelt. We're going to have to get into a little discussion about that. They don't want to talk about that. Let's get back into this.
You're talking about the doctrine of unconstitutional delegation of legislative authority, which is a bad name for it because there is no such thing as a constitutional delegation of legislative authority. You cannot delegate legislative authority. Now, when you give rulemaking to an agency, how far can you go? Can Congress just get together and say, the president can do anything he wants and adjourn? Of course not. That has to be unconstitutional. But is it up to the courts to decide where the line is drawn between giving enough authority to the chief executive and too much authority? It is simply a non-justiciable question, and I, for one, would not let the courts apply the doctrine of unconstitutional delegation, where the delegation is to the executive.
As long as it's to the executive branch agency, then even
I wouldn't get into it. Some of my colleagues would, I suppose.
Even in the extreme situation where we passed a law saying, for example, we shall have good law. The power to make good law is hereby delegated to the Department of Good Law, which is hereby created.
I'd do that one, all right. But that's not going to happen. I'm talking about any real situation. I can't imagine my sticking my toe in that water.
Okay. And Justice Breyer, I had a question for you. I've really enjoyed reading parts of your new book, Making Our Democracy Work. It's very well written and fascinating. I think it's good reading for any law student or lawyer or American who.
Breyer come in, he started kissing his ass. Justice Breyer, I really enjoyed reading your book. Go check out Justice Breyer's nationality. Just had to throw that in there.
Wants to learn more about the system. You suggest in your book, at page 126, that there's rarely an easy answer to the question of what level of government should be primarily responsible for helping to resolve the problems that potentially call for legislation, and that the question usually turns on empirical information such that facts help determine the answers. Yeah. You go on to explain in pages 125 and 126 that very often this means that the courts ought to step aside and, if I'm understanding you correctly, have Congress more or less decide the precise contours of the boundaries of federalism. Is that, am I understanding the book correctly in that regard?
Yes, that's right. I think it's, because you go to abstract, but it's just, if you start talking abstractly, the trouble is you can characterize any individual situation usually in 15 different ways at different levels of abstraction, and depending on how you characterize it, it'll seem appropriate for a federal answer, or it'll seem appropriate for a state answer, a local answer. Is it a police department problem? You say, well, it's arresting somebody. Yeah, but you're arresting them for having guns. And, well, it's a state problem. Well, but the guns are torpedoes and they're only made internationally. And so that's so complicated and difficult that it's hard for the courts to find a general principle there. That's my point there, and that's why.
So if that's the case, and if it's also the case that under, as we read in Federalist number 45, the powers of the federal government are few and defined, whereas those of the states are numerous and indefinite, then members of Congress should read the Constitution, decide what those contours are, and restrain ourselves rather than waiting for the courts to step in and say, no, you've overstepped the bounds.
No, my point that I was making there is you are elected by officials in a state, and so you will make such judgments on such matters as you believe are appropriate in light of how people, partly how they feel and partly what you're trying to represent, but that it is a lot of that is your decision.
Right. Senator, of course you have to make those constitutional decisions. You take the very same oath that I take. The only reason I can look at a federal statute and say I have to disregard this because it does not comport with the Constitution, the only reason is that I've taken an oath to uphold the Constitution. You take the same oath. So, and we give deference to legislation on the assumption that the members of the Senate and of the House have tried to be faithful to their oath. And if indeed they're not even looking at or even thinking about the constitutionality of it, that presumption should not exist. So.
Are y'all starting to understand why they don't like Scalia? See how he just came in right behind Breyer and said, of course you got to follow the Constitution. I took an oath just like you took an oath. You know, this thing about the guns. I remember I had a case where a guy, young guy, I'm always talking about this. He was a little drug dealer in Florida. He got caught in he was a small little drug dealer. He, not big time at all. Probably little fuck baggies and shit, probably nowhere, nothing, just a small corner drug dealer. And the feds picked him up, and he was in a hotel with his girlfriend, and he had a gun. And so they charged him with the gun and all of these, and he had like some baggies of drugs or whatever. And anytime somebody would bring their paperwork to me, the first thing I would always look for in their indictment was the jurisdictional element that granted jurisdiction to the feds, because the feds only deal with interstate commerce. Okay, when you read any indictment, you're going to see that they violated. I'm going to show you some indictments. We'll look at Tekashi 6ix9ine, maybe Winston Strout, and other people in purple indictments, and you're going to see almost every time that's in there that they violated interstate commerce, and they use all this commercial terminology. There's corrupt organization, racketeering and influence and corrupt organization. All these business terms that you're going to see that they're using. And they still going to throw in your face like it's not commercial. 27 Code of Federal Regulation 72.11, commercial crimes, what they regulate. And what they said was the gun was manufactured in another state and brought across state lines. And that's how they picked up the case. Interstate commerce. So you need to be aware of that if you out there doing something you shouldn't be doing and you don't want to catch a federal case. And they have expanded the application of the Commerce Clause, which is Article 1, Section 8, Clause 3, so big that it almost encompasses everything now. They've turned everything into something commercial in nature. Almost everything. That's how they have this. That's why you are under their jurisdiction. That's why the republic is a house no one lives in. No one's in the republic. That's why they keep pushing democracy, democracy, democracy. I'll show you the document from the military to show you what a democracy is. I got a video on here already talking about it from the military. We don't have a democracy. We have a constitutional republic. And a republic respects the rights of the individual. And a democracy is mob rule. It's socialism. That's why they keep the word democracy ain't in the Constitution. It's not in the Declaration of Independence. And it ain't nowhere in the Pledge of Allegiance. You did not pledge allegiance to a damn democracy. You pledged allegiance to a damn republic. Your flag stands for republic, and to the republic for which it stands. I ain't never heard it said to the democracy for which it stands. They didn't program y'all mind, and y'all think democracy mean freedom.
Yes, of course you.
So in that respect and to that degree, our oath to uphold the Constitution, our commitment not to overstep the bounds of federalism, means more than simply doing that which NLRB versus Jones and Laughlin Steel or Wickard v. Filburn might say that we can get away with in court.
Well, I think you have to make your own decision about constitutionality. In normal times, you follow what the Supreme Court law has said. But we don't strike down any of your laws. People sometimes go, the Supreme Court struck. We never strike down your laws, gentlemen. We just ignore them. Where your law does not comport with the Constitution, it seems to be a law but really isn't, and so we ignore it and apply the rest of the law, the statute notwithstanding, as one of our early cases put it. But it's really you have the first cut and the most important cut.
They had to get rid of his ass. They had to get rid of him. Like, what, nigga? And so we passing. You hear what he said? What we can get away with. They pass unconstitutional things all the time. Your Supreme Court justices are supposed to be the watchdogs of that. But the only way that they would issue a certiorari on it is you got to challenge it and bring it to their attention. But most of you don't know because you don't know what's constitutional and what's not constitutional. So they don't worry about it. He said, we just ignore the part that is unconstitutional and apply the part that is. Because they will they do it all the time. He said, we don't strike down your laws. We just ignore the part that's not constitutional. Well, hell, if they ignore it, how are we supposed to ever know it was unconstitutional if you don't put it in your opinion? Saying a federal court is a court of limited jurisdiction, of course it's a court of limited jurisdiction. Where is that jurisdiction derived from? The Constitution, Article 1, Section 8. Of course it's limited. That ain't saying shit. They ain't telling me shit to say the federal court is a court of limited jurisdiction. They use that word federal to throw you off. When they say federal, they mean legislative. They mean congressional. Telling me it's a legislative court lets me know some stuff. Telling me it's a federal court, now that don't tell me shit. That's one of those words they implemented to throw you off, like United States. Like United States versus the United States of America. You don't think there's no appreciable difference between the two. Just like Federal Reserve. They got you thinking Federal Reserve is federal. the Federal Reserve. It is a reserve for the federal branch of government because Congress, what? Congress, that's the the legislature. They're the ones that's supposed to coin the money. So they have the reserve for the federal, for the legislative branch of government. That's why you have the Federal Reserve Act is what? It's under Congress. Can y'all put this together in your mind, man? This is simple. This is basic civics, which 90% of the population does not possess. Basic civics. I see why they took Schoolhouse Rock off the air. I see why they did that. They took it off the air. I see why they did that, you know. I see why.
Thank you. Thank you, Mr. Chairman.
Senator Lee.
Thank you, Justice Scalia and Justice Breyer, for joining.
Now I'm going to do a video and we're going to talk about how they treat a judge who is not a Article 3 judge. I want you to see the difference. I want y'all to see the difference. This is Senator Gowdy grilling a judge. And I want y'all to see how they treat this judge. I want you to see the difference and how a Article 3 judge who's on the same level
Joining us. It's an honor to have you here today. Justice Scalia, I wanted to follow up on some things you had said in
All right, let's look at that. Now, this is a different judge. Watch how this senator is talking to this judge. All right, watch how he talks to this judge.
Thank you, Mr. Chairman. Judge Craftsher, I'm going to read you a quote, and you tell me whether or not you know who said this, okay? 100% of the women at call centers have been abused. It's an atmosphere of abuse. Anytime we see a call center person, female, all have been abused. Do you know who said that, Judge?
I did, but it's taken out of context.
Well,
Sir, your microphone, can you repeat that, sir?
Yes.
he said it was taken out of context. Well, let's put that in context. Judge, did somebody testify to that at a lower level? Was that in the record?
No, sir, that was my experience.
Did you rely on a learned treatise? You made a point of saying in your opening statement how much respect you pay to the federal rules and the Constitution. Was that a learned treatise you relied upon, Judge?
No, that was my experience over 20
So you
years.
made yourself a witness even though the federal rules are very clear that judges are not witnesses. Is that what your testimony is, Judge?
That was my opinion, not any others.
100% of female employees at call centers have been abused.
I didn't say that. 100% of the people that appeared before me have been abused.
And you relied on no learned treatise, no testimony at a lower level, just your innate sense of medicine?
No, that's been my experience having hearings.
Well, let me ask you about another one of your experiences, Judge. I want to read you another quote and ask you whether or not you recognize who said this, okay?
Mm-hmm.
How did your family discipline you? Did they hit you on the butt? I'm starting to do some analysis. It's starting to be when women are hit at an early age, they start developing problems in their 20s, late teens and 20s. My ex-wife told me about this. There's something in a girl that's a sexual thing. It arouses certain things. Did you say that, Judge?
Yes, I did.
Did you rely upon a learned treatise in reaching that determination?
No, I relied on...
Did you rely on something at a lower level, a hearing, a witness testified to that?
No, I relied on my experience hearing case over 20 years.
Judge, I hasten to add, because you made a point of saying in your opening statement that your first responsibility is to the Constitution and the federal rules of evidence. Are you aware that judges can't be witnesses? Are you familiar with that, Judge?
I don't consider myself a witness.
What you want in a hearing. Is that what you're saying?
No, sir.
And you can rely upon that when you're spending taxpayer money?
No, sir. But that's an isolated case.
Well, it can't be an isolated case. I just cited two.
Yeah.
And my colleagues cited others.
Yeah, you're taking isolated cases. I've had.
Well, let's go a little broader than that, Judge. What is your reversal rate of the hearing officer? Is it in excess of 90%?
Yes, it's based upon testimony given to me.
All right, and it has to be adjudicated twice before it gets to you, right?
That's correct.
And only if it's denied does it get to you. So 90% of the time, the people under you are wrong.
No, I want to be able to cross.
Well, it has to be, or you wouldn't be reversing them. They've denied benefits, Judge, and you've reversed their denial. That means that you're hiring some really dumb people to be hearing officers because they're wrong 90% of the time.
No, sir. I want to be able to cross-examine the people from Social Security.
I'm glad you mentioned cross-examination.
Right.
I can't tell you how glad I am.
Yeah.
Because in every other court proceeding, there is someone cross-examining the witnesses, but it's not a judge. It's an attorney, and that's true in misdemeanor crimes, that's true in felony crimes, that's true in civil cases. So what I think you need, Judge, is I think you need an advocate and an attorney for the taxpayer in the hearing room. Because I don't want you cross-examining witnesses. If you really think that paddling a child leads to sexual issues, I don't want you doing the cross-examination. And if you really think that 100% of CNAs have been abused and 100% of females in call centers have been abused, I don't want you doing the cross-examination, Judge.
Sir, we wear three hats. One hat is the Social Security hat. The other hat is the claimant's hat. The other hat is the Social Security hat.
Where's the expert witness hat? You just said you were an expert witness.
We have an adversary system, and I have the right.
It's not an adversary system. There's no advocate for the taxpayer that's in the courtroom.
We have a non-adversary system, sir. It's a non-adversary system, and I have to wear three hats.
It can't be too adversarial, or you would not reverse the hearing officer 90% of the time. And some of your colleagues, 99% of the time, they reverse a hearing officer. And we mistakenly, Judge, thought it was because you were eyeballing the witnesses so you could assess credibility. But we learned from your colleague, Mr. Taylor, that that's not even true. Sir, you don't even have a hearing. You just do it on the paper.
Sir, it's not eyeballing the witness. I take testimony. I have had here, this sheet has...
And who does the cross-examination?
It has 186 ailments on it.
Who does... Well, that's your document. Mr. Cummings,
no.
Mr. Cummings just exposed it. That's your document.
No. The attorney also provides one for me.
The attorney for whom?
For the claimant.
That's my point. There is no attorney for the taxpayer.
Good.
We're going broke. Mr. Chairman, I know I'm out of time, but I'm going to tell you a story from Spartanburg real quickly. I had a judge call me. He's apolitical. And he said, I just sentenced someone for calling under people's houses and stealing their copper. And he said, what really struck me as being unusual, Trey, is he is 100% disabled in the back. I want you to think about that, Judge, and I want you to think about one other thing, too. I went on a tour of something called a workability center, where people with special needs value work enough that they go to work every single day. And there was one man who was confined to a wheelchair, had no use of his hands or legs, but his job was to encourage his fellow employees. There is inherent value in work. And one reason your backlog may be so big is because it's so damn easy to get benefits.
Not for me. Not for me. I hear every case. I see every person that's ever appeared before me. Everyone.
You reverse the hearing officer over 90% of the time, Judge. 90% of the time, the person at the first level is wrong in your judgment, and you are citing your own version of medicine. 100% of the people are abused. That if you paddle a little girl, she's going to wind up with sexual issues, despite the fact it's not in the record, Judge. Well, you may be a judge, but you're not God.
Well, let me explain to you. If I had this person in front of me that was down below, I can examine him on behalf of Social Security, and that would allow the claimant's rep.
Well, then why don't your colleagues have hearings? Why do they do it on the paper? If it's that important to eyeball a witness and assess credibility and cross-examine them, why are you doing it on the paper?
That's what I said in my remarks here. We need the ability to be able to have the witnesses who give any comment down below should be appear before me, so I can examine them, and they can be cross-examined by the.
I want them being cross-examined by an advocate for the taxpayer, Your Honor, with all due respect, not a judge.
Well, they need an adversary system, which we don't have today.
Mr. Horsford.
Thank you, Mr. Chairman. Judge.
Now, that judge exposed some stuff at the end. He said, we don't have an adversarial system. Notice in the beginning, he said the federal rules are, look at this word federal rules of civil procedure. Okay. He expects, this is an employee. This is an administrator. He's administrating. So the senators have authority over him. See, they not don't come into under a separation of powers. This is not a true judge. See, a true judge has lifetime tenure and protection from salary diminution. The reason for that is they cannot let a judge's job or salary be compromised so you can influence their decision making. They have to be free of all of that. Now, they've clothed some of these administrators with that same thing too, to fool a lot of y'all, giving them lifetime tenure, but that does not give them judicial power. They have legislative power. This is the primary thing. If you're out there watching that we're talking about, ain't nobody talking about we don't have to be subject to any law. Fool, what are you talking about? Ain't nobody saying that shit. There's no such thing as not being under any law. Everything in the universe is subject to some kind of law, whether it's natural law, man-made law, positive law, however you want to style it. Nobody's saying that. We want to know the nature of the action. We want to know if you're operating within the ambit of your delegated authority, or have you exceeded that authority, exceeded it. That's what we're trying to find out. And as our public servants, I should be able to ask you this fucking question. Why would an innocent person take a plea deal? I just pulled this up on the internet. Let's just read what they're saying over here. Okay, putting all your eggs in one basket and hoping you will be cleared of all charges might be nerve-wracking, whether this is your first time facing criminal charges or if you are innocent but face a serious penalty. The help of a criminal defense attorney can allay your fears and help you explore what legal options may be within your reach, even if it's a plea deal. Well, it's going to always be a plea deal. In the U.S., wrongful convictions have stripped many people of their freedom. So if you have been charged and are facing a serious penalty, it is understandable why a person would take a plea bargain even if they are innocent. However, the prevalence of plea bargaining sometimes has more to do with efficiency than guilt. Did you hear what they just said? It's more to do, and that's absolutely true. We don't want to waste the judicial resources of the court. Do you know that if just, I think about 10% of them people or 15% of the people decided to take their cases to trial, they could shut down the judicial system? That's something like 15% more. Criminal charges can feel like the end of the road, while a plea bargain can feel like a second chance with the right legal support. This article will dive into the specifics behind the choice to accept a plea, focusing on the history of wrongful convictions and exploring the many reasons why a person may take this route. The history of innocent people receiving jail time in the U.S. Reports from the Prison Policy Initiative state that there are roughly 1.9 million people in prison or jail as of 2023, including legally innocent people awaiting a pretrial. In the U.S., the history of innocent people facing incarceration largely includes communities of color and continues to grow due to biased juries, coerced confessions, faulty forensics, and combative policies. And that's true. They will do anything to get a guilty plea out of you. You know, a guilty plea kills all known and unknown defenses. So when you plead guilty, there ain't no liability on nobody. That's one of the main reasons why they want a guilty plea out of you. A guilty plea kills all known and unknown defenses. Y'all better write that down. At times, the criminal justice system can be unfair. At times, as shown by the following statistics. 47% of exonerated persons are African American, even though they make up roughly 13% of the U.S. population. There are only 95 conviction integrity units, CIUs, operating to date that have helped to secure over 50% of exoneration since 2021. The National Registry of Exonerations reported that the largest number of exonerations in 2018 was from cases in which government officials showed misconduct. God damn. They do it all the time. There ain't no oversight over these people. There's no judicial oversight. I'm trying to tell y'all what's going on. Y'all think because somebody plead guilty, they guilty? They plead guilty because the court trial is a dog and pony show. And you're going to get way more time for going that. They hold that over your head. You mean I got to take a plea deal so I can get less time, but if I want to go and fight for my life and liberty, I got to risk getting more time? That's what you're putting before me. So if you're putting something before a person and you say, well, look, we're going to give you this 30 years, but if you plead guilty, we're going to give you 5. What you going to think that's going to do to a person's mind? You ain't got an attorney that's helping you do nothing. You ain't put in no evidence in the record. You ain't filed an affidavit. Out of 90% of the cases, if you're an attorney listening, you know what I see in the file? All you file is a motion to suppress and a motion for bond. Taking somebody money, let them walk around a little while, and then about 8 months later, hey, you know what? It's my duty as your attorney to, just tell you this. The prosecutor's offering you a deal. I think you ought to take it. They're offering 7 years. You can do 10 years probation. I think this is good. Now we could go to trial. If we go to trial, I'm going to just tell you, you're looking at 15 years. All right. But I think this is a good deal that the prosecutor's putting before you right now. You take this 7 years and do these 10 years probation. They ain't telling you that probation is still incarceration. You're really getting 17 years. You're getting 17 years. There are many reasons why innocent people end up entangled in the prison system. The presence of defective frameworks like mandatory minimum sentences and underfunded public defenders. They ain't underfunded. Public defender don't do shit no way. That's why we got to give an instruction letter. You don't take a public defender without giving them instructions. Why would you? Everybody know public defender ain't finna do shit for you. The only public defender that I have seen that have actively attempted to help their client was somebody coming straight out of law school. They green like a motherfucker. So it goes on. The presence of defective frameworks like mandatory minimum sentences and underfunded public defenders adds to the reasons why innocent persons may be forced to accept a plea. Is taking a plea deal the same as pleading guilty? Although a plea deal entails the defendant agreeing to admit guilt to one or more charges in exchange for the prosecution making certain concessions, it is still different from pleading guilty. A defendant enters a guilty plea, forfeits their right to a trial, and admits the allegations brought against them, unless the defendant successfully argues for a more lenient penalty at the sentencing phase. This usually results in a conviction and a sentence. In contrast, a plea bargain is a settlement reached by the defense and the prosecution in which the accused consents to admitting guilt to one or more offenses in return for some form of advantages. This could take the form of a lighter punishment, lesser charge, or dropping of additional accusations. It is crucial to remember that accepting a plea agreement is a significant choice that shouldn't be made hastily. Before accepting a plea bargain, the defendant should speak with an accomplished criminal defense lawyer who can inform them of the possible repercussions and assist them in making a decision. What reasons would an innocent person have for an accepting plea offer? The criminal legal system contains several incentives that contradict the truth, including arrest quotas and crime labs compensated by conviction rather than forensic tests. So when you think about it, an innocent person choosing to take a plea deal isn't the most illogical thing. One may feel inclined to take a plea deal for the following reasons. Prosecutors have power. Prosecutors frequently have tremendous negotiating power and may scare a defendant with a heavier penalty if they decide to go to trial and are found guilty. Even if a person is innocent, they can believe it is not worth it to risk getting a harsher penalty after trial. That's the number one reason. That's why they put it first. Most people have financial limitations. Attending a trial can be quite expensive, and many defendants simply do not have the funds to cover the cost of a lawyer and other related expenses. Therefore, you might believe accepting a plea deal is the most financially responsible course of action, even if you are innocent. Remember about my attorney friend told you, if you listen to another, he said, we test y'all on resolve and resources. What is your resolve? How far you want to take it, and what are your resources? You got money? You got knowledge? Okay, what type of resources do you have at your disposal? That's what you get tested on. Resolve and it ain't about the truth and the whole truth. It's like you told me, it's what you can prove. You have resolve and resources at your disposal. Come on, man, you're an attorney listening to this. Don't you know I got attorney friends? What, you don't think I hang out with attorneys? I'm just some loudmouth nigga over here just talking, huh? Coercion tactics work in stressful moments. In some circumstances, defendants may be coerced into accepting a plea deal by law enforcement personnel who may utilize coercive tactics to get them to confess to a crime they did not commit. And this is why you got to understand the Fifth Amendment. You have the right to remain silent. Anything you say can and will be used against you. Do you hear that when they say that, man? There is a video on YouTube that you need to watch. It's called Don't Talk to the Police. You are derelict in your duty to your children, and in particular, if you have a son, if you have not required him to watch that video and might write a goddamn book report on it. It's two parts. One is from an attorney, the other is from an investigator. Don't talk to the police. Y'all run y'all damn mouth too much. Bill Cosby and Mike Tyson wouldn't have went to jail if they would have kept their mouth closed. When it is your word against someone else's, all you have to do is be quiet, because the burden of proof is on he who asserts and not he who denies. When the police come and ask you questions, they are trying to corroborate evidence. You ain't finna talk your way out of shit. They want you talking. Shut the fuck up. There's a history of injustice. Sadly, some innocent defendants may feel that the court system is biased against them and they are unlikely to obtain a fair trial due to their lack of faith in the judicial system, which is warranted. When we get through, I'll get through showing you everything. That's warranted. In certain situations, some accept a plea bargain to reduce their chances of being wrongfully convicted at trial and face a harsher sentence. I want y'all to think what Polite is going through. I don't know if Polite is innocent or guilty, but this is what I've been trying to tell these brothers. Let's say, man, because somebody accept a guilty plea don't mean they're guilty. This is what they talk about Dr. York and other individuals out there. You know, I say, because I understood all of this. I never said anything, but I was like, man, look, you know, especially our people, they know that the judicial system is biased against black men, but you have the unmitigated gall. Oh, yeah, he guilty. You don't ask no questions. I'm not saying he is innocent. I don't know. He may very well be guilty. There are guilty people. There are people who kill people. There are people who rape people. There are people who steal. There are people who do all type of heinous crimes. I'm not in any kind of way suggesting that. And that is the conundrum that they have to deal with when we're dealing with this type of information. That's why one of the rules is you have to be an honorable individual. If you're not an honorable individual, don't think you're going to get away with anything. You're not going against these people. You're going against the creator of the balanced universe, fool. You have to answer for you don't get away with nothing. And that's what they mean by fear the Lord. Fear the Lord means fear the law. Fear the natural laws of God. Karma is a law of God. An eye for an eye, a tooth for a tooth. If you live by the sword, you will die by the sword. That's why they're taking religion away from you. They don't want y'all talking about God or nothing like that. They don't want you because the further they can take you away from God, the further they can take you away from natural laws. You'll just be a lawless individual. You'll be a heathen. And they are authorized in Leviticus 25:45 to make slaves out of heathens. And that is what we're talking about right now, because the prison industrial complex ain't nothing but slave plantations. Slavery wasn't eliminated by the 13th Amendment. It was moved to the prison industrial complex. And all they got to do is make you look like a criminal, and ain't nobody going to question slavery. Attending a criminal trial may be a protracted and emotional taxing process. Innocent defendants might just want to put the case behind them and carry on with their life, even if they're convinced that they will be exonerated at trial. Accepting a plea bargain may be a way to get closure while avoiding the anxiety and unpredictability of a trial. And that's what happens. That's what I call fatiguing you into compliance. All right, you have to come back for 2 years. We got another court date set, another court date set. This shit been going on for 2 years. I got a client right now, been 2 years, been dealing with this. Yeah, another court date set, Yeah, no witnesses or nothing. I've been seeing situations like they ain't got no witnesses or nothing. They still won't drop the case. They still won't drop it. Why? You're an attorney out there. Why? If you're a prosecutor, why you won't drop the case and you know you don't got no evidence against the person? You probably know the person is innocent. You still won't drop the charges. Why is that? I don't think it's because it's something in your character. I think it's something in the nature of the system that involves liability, like what we're talking about. And could it be something like this right here? Let me see that. Could it be this right here? Let's see if I can pull this up. Could it be something like this? Now, this cost thing, I had to do some research on it. Okay, so it's assessment of cost. Now, this is criminal procedure. This here in Georgia. So we're talking about the imposition, assessment, and payment of costs on the criminal proceeding. General provisions, imposition of costs and jail fees upon the prosecutor or complainant. This is for the prosecutor. OCGA 1711-1 is on the defendant. If he's found guilty, they put a lien on him. Now, this is what I'm going to show you this. It says, the prosecutor's name shall be endorsed on every indictment. Now, you have this in the federal rules, too, where it talks about the indictment. I've seen indictments that they name ain't on it. I've seen indictments where you don't have it ain't even been signed by the grand jury foreman. The prosecutor's name shall be endorsed on every indictment, and he shall be compelled to pay all costs and jail fees upon acquittal or discharge of the person accused when, number one, the grand jury by its foreman on returning a no bill expresses as its opinion that the prosecution was unfounded and malicious. Number two, a jury on the trial of the prosecution finds it was to be malicious. Or number three, the prosecution is abandoned before trial. When it is thus abandoned, the officer who issued the warrant shall enter a judgment against the prosecutor for all costs and enforce it by execution in the name of the state or by attachment of contempt. Let's look at what an attachment is. What is an attachment? This is how you find it in your state. Study everything that have to do with writs of attachment. If you're looking for a doorway into what I'm talking about, and because all these state statutes are different, just start studying attachment liens. So we're going to go over here. I go to blacks. We're in SPC University right now. So let's go to this Black's Law 8th edition. And let's go to A's. Let's look at an attachment. What is an attachment? It say you're going to issue it because what do they say again? They say we're going to do what? They said we're going to do what? We're going to execute it in the name of the state or by an attachment for contempt. Attachment occurs 52 times in the A section. Attachment. The seizing of a person's property to secure a judgment or to be sold in satisfaction of a judgment. also termed provisional seizure. All right, so you got attachment of wages. Then down here, we're going to go down, and here goes the second sense of the word. The arrest of a person who is either in contempt of court. What is that right here? What they say? By execution in the name of the state or attachment for contempt. The arrest of a person who is either in contempt of court or is to be held as security for the payment of a judgment. So we're talking about a creditor and debtor relationship. Let's look at this and see. Let's look at some things, because are we talking about a creditor and debtor situation? Because they'll have you believe that, no, we're not. We're not talking about any of that. All right? We're not talking about any of that. Let's see. So we go back over here, and I'm going to use Georgia because I was doing all my research in Georgia. So I'm going to go back to the Georgia, because I was in Georgia when I was researching all this. So I was researching a lot of state statutes. So we go over here to Title 17. OCGA stands for the Official Code of Georgia Annotated. And so if we go to where is it? Oh, this criminal procedure. Hold on. That's not what I'm looking for. Georgia codes right here. All right, so you can see right here, we got debtor and creditor law, Title 18, which is just another name for admiralty. So first, let's look at debtor and creditor relations. So we're going to look at a principle. This applies in all states too. All right, so watch this right here. It says, general provisions. Creation of relationship of debtor or creditor. Whenever one person, by contract or by law, is liable and bound to pay to another an amount of money, certain or uncertain, the relation of debtor and creditor exists between them. Okay, so anytime y'all talk about owe some money, it's a debtor and creditor relationship. Now, this is in the criminal procedure. So when we go back over into OCGA 1711.1, let's look at this again. OCGA 1711.1 under criminal procedure, 1711.1, imposition and cost of the prosecution on the defendant. This is criminal now. It says the cost of a prosecution, except the fees of his own witness, shall not be demanded of a defendant until after trial and conviction. If convicted, judgment may, this word may means must. It means must. You go down and pull the book off the shelf and read the citations of authority. The judge explains that to you. They get into an exact, that's why you need to go to the law library and pull the books off the shelf and stay off the internet. I'll see if I can find it. But it says the cost of the prosecution, except the fees of his own witness, shall not be demanded of a defendant until after trial and conviction. If convicted, judgment may be entered against the defendant for all cost accruing in the committing and trial courts and by any officer pending the prosecution. The judgment shall be a lien from the date of his arrest on all the property of the defendant. How can you put a lien on all my property? The only way you can put a lien on all my property, it got to be my social security number. How the government gonna put a lien on all my property? How you gonna find it? The only method you got of finding all my property is my social security number. Now you starting to understand why they don't want y'all filing UCC ones? This is a lien. A lien is evidence of a debt. Anytime there's evidence of a debt, a debtor and creditor relationship has been established. How long I've been rolling today. I want to thank everybody for the donations. What time is it? It's 7 o'clock. I'm gonna do a part 2 of this tomorrow because I gotta get ready to get up out of here. But I'm giving y'all some information to do your own research. I'm so sick of these people. They trying to make people look like they crazy, that somebody is scamming somebody or something like that. You think I did this much research with the intention on scamming somebody? That's an insult. That's an insult. They're gonna scam somebody? I wasn't even thinking about being on the internet when I learned all this stuff, tell you the truth. I wasn't thinking about none of this stuff. Never thought in a million years I'd be on a YouTube video talking to you and having to have courage to do it. Because you don't think these people don't like what I'm saying right now, you're tripping. But see, that's why I had to come and tell everybody so you can go and do your own research. You got to do your own research, man. You can't just expect me to just find all the information. You know how big these law books are? It's impossible for one person to find out everything on this. You got to do a concerted effort. You have to build off the research of the people that came before you. That's what I did. I took the research of the people that came before me and just built on it. If you ask the creator for the boundless universe for guidance, he will give you guidance. Everything you need will be provided to you. But you got to get back in, a lot of y'all done drifted away from the creator. I don't like to use the word God because God tends to, paint a picture in people's minds of some white man in a cloud with a long beard, some sort of anthropomorphic representation of God. When I say God, I'm talking about the all. I'm talking about a universal mind. I'm talking about an energy, a universal energy that pervades every single inch in space of the universe, that's at your beck and call at any infinitesimal moment. You have access to it. That means that no one is greater or lesser than you. Anyway. $50 years of 5 years probation, which you take. That's exactly right. And see, that's what they don't understand. That is what is being offered to people. So all the people, they saying, well, you're trying to use these strategies to get out of trouble. Well, almost 100% of the people that come to me, they went to an attorney first. And all of them have the same experience. They went to an attorney first. Some of them paid an attorney a lot of money. I remember one time a guy came to me for some help. He came to me for some help, and he wanted me to help him do something. I think I was going to charge him $1,500 or something like that. He didn't want to pay me, so he went to an attorney and gave an attorney $40,000. He called me the day before his case and wanted me to help him. He called me 7 o'clock at night. His case was 8 o'clock in the morning. He wanted me to write a paper for him. I charged him $500. I'm like, man, why you going to call me the day before your case? I did it. I didn't expect him to win. Not no one day before. You go in the case. What am I going to do? I probably shouldn't have took his money, all right? But he begged me. I really didn't want to do anything. But he begged and begged for me to help him. I only charged him $500 just for my time for writing the document. He went the next day and lost. He called me back and asked for his $500 back. And I asked him, I said, did you ask an attorney for his $40,000 back? And he said, fuck you, and hung up the phone on me. You mad at me, and that's what y'all do. Y'all come to us looking for us to walk on water. You don't do none of that shit to the attorney. You don't ask for your money back. You don't say that they scamming you. You don't use any of those things on them. They take people's money every day. I used to date an attorney, and we were sitting at a table talking one day, and I asked her why people don't like attorneys. And she sat up there and told me with a straight face, because we take y'all's money and don't do nothing for you. And y'all know I'm telling the truth. all you paying them for is to get you a plea deal. Maybe if you pay them a lot of, let me ask you a question. Let's say you out there and you got some millions of dollars in a wall or something like that, and you go pay an attorney $100,000, and he keep you out on the street for 2 years. If I was an attorney, I wouldn't let your ass get locked up either. Nigga, you got money somewhere, I'm going to keep on trying to milk your ass for money until I can't get no more, and when I can't get no more, I'm going to let your ass go to jail. But you're a source of income. Why would I hurry up and make the case go away in a situation like that? Somebody said, and that's the problem right there, Marl, Jane. Now, I will say this. I understand but see, the problem with you just say is that, yep, you're right. If I can get me the least amount of time possible, I ain't got no complaints. That type of mentality is the problem. I understand you should have a complaint. You should get the least amount of time. Now, for a motherfucker that's guilty, yeah, you're right. You guilty, you out there did some shit, yeah. Yeah, you're right. Because you sound like you did some guilty shit. You sound like a guilty person. I'm talking about why innocent people. You gonna be happy as an innocent person, you took a plea deal and you ain't do nothing, and you gonna be happy with that? I ain't talking about somebody innocent. I'm talking about somebody guilty. I mean, I ain't talking about somebody, I'm talking about somebody guilty. Ask the Creator for knowledge, wisdom, and understanding, and it led me here. Also, you get into the point is the understanding that abiding by the law is the best bet in life. And more importantly, God's law. The problem why you having so many problems, let me talk about why people have so many problems, especially to you individuals out there. You constantly getting arrested. You constantly getting pulled over by the police. You constantly with somebody. It's always some type of issue. The issue is that you don't understand that there are no victims in the universe. That you draw to yourself what you think about all the time. If you are a negative person, you're going to constantly attract negative situations into your space. That's the law. That's the law. And it's going to operate with mathematical precision. This is why you hear people say that the first step is you got to get positive. And positivity will start when you start understanding how the law operates. That's when you begin to have faith. See, faith, there's something called blind faith. I'm not talking about blind faith. I'm having faith because I understand the laws of God and how they operate. And I know that they are immutable, and they operate with mathematical precision. They operate all the time, 24 hours a day, 365 days a year, without fail, every second. So once you understand the laws and how they operate, now you can have faith. Now we can get rid of fear. Fear is the absence of knowledge. Fear is false evidence appearing real. Fear is an illusion. How can you have fear and God created the universe out of love? There has to be some ignorance. There is no money. Public and private do not mix. Stay in honor at all costs and do not participate in public controversy. I'll see y'all tomorrow. Thank you for the donations. Peace to the gods. I'll see you tomorrow.